Karl, I spoke with earlier regarding going into the court, and what they said is if I go in there and I don't have a entry of appearance from a attorney, they're automatically going to give me a public pretender, and or they would proceed with the hearing right then and there. If they have their way, they could probably go remand it right to jail for a traffic ticket.
Yeah, but I told you. What did I tell you before to do?
I am looking that up right now. Basically, what you said is, do you use the word Your Honor?
No.
You ever call a judge Your Honor?
I asked him how is he. Like I said, if you do this kind of nonsense, you start talking, you're going to jail.
Okay.
And you're going to put up with your shit. Now, when here in Virginia, everybody introduces themselves. The judge will introduce the parties. Mm-hmm. You know, and he'll explain who he is, and that's what he'll be addressed. Now, you're in Pennsylvania. I don't know if he's going to waste his time to do that because it's administrative. Mm-hmm. So he probably won't even be in a robe.
So basically, I require the court to show I, a man, in the law, where there is a requirement in law for a man to have a license and to take and carry my property where I may wish, or for a man to lawfully comply with any of these charges. Show me the law, and I will comply, and I will admit to you the debt you demand. Furthermore, if there is any man who is an injured party with a claim present today, have him come forward and state so on the record. Further notice, I don't speak or understand, neither am I a contract or applicable to your code. Neither am I in a contract with or applicable to your code, foreign to me. Further, Your Honor, I hereby invite the court to take cognizance and hereby notify the court of the fact that if anybody does anything on my behalf here today or afterwards, since I will not suffer these injuries further, they are acting under full liability. Please be notified, number one, I do not understand even the nature or cause of these allegations. Number two, I positively do not consent to any of these unlawful or even fraudulent proceedings. And number three, jurisdiction was explicitly demanded in a timely manner. The actor failed to timely respond, was provided an extended time on 3 separate court special visits, and therefore has, by the doctrine of tacit procreation, admitted no jurisdiction exists. And since the accuser, admittedly a corporation and not being a man, knew where this living man was in prison for delivery of same proof and failed to do so, therefore he is now in default. Plus, due to the false and misleading statements made to the authorities, this matter requires to be immediately discharged and the injury made right by all wrongdoers, since this man will not suffer this conduct further.
Could anybody possibly imagine that this is what I said to the man a half an hour ago?
No. I ad-libbed a little bit.
I gave you 8 words. I said 8 words. I said, whoever acts on my behalf assumes all liability. So how did you get that? The judge is going to say to you, if you don't come in here with counsel, if you don't come here with an attorney, blah, 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 blah. You just say, fine, whoever acts on my behalf assumes all liability. How hard is that? I mean, that was your original question. If people go back 27 minutes ago when you first started talking, it'll clearly say, I got to, what did I say to you? I said, whoever acts on my behalf assumes all liability. That's all. You say, fine. That's all. How tough is that? I don't know. See, like I said, you just, this is
whoever acts on my behalf will incur full liability.
Yeah. Go ahead. Just keep adding words. Yeah, that sounds lovely. Yeah, just keep doing that. Just, That's what I said to you before. I said the next time you call me, buddy, you better have a recording device, because this gets really frustrating.
That's a good idea.
Well, I said 8 words to you. Somehow you turned it into 8,612. Yeah, I was counting.
Whoever acts on my behalf assumes all liability.
Yes, that's fine.
Whoever
wishes to act on my behalf assumes all liability. That's all. How tough is that? But you do that silly, ridiculous nonsense. You just said you're going straight to jail. You think they bounced you once before, they're really going to bounce you. You think they roughed you up last time? Yeah, go ahead and really piss them off. What's great is I have the phone call I had with him on the airplane in L.A. So it's funny, I should upload the answer I gave him. That when I gave him in L.A. and then match it up.
It is very simple.
Yeah, and then match it up with this one. He said, well, Carl, this is what you told me a little while ago. Yeah, 8 words.
No, you didn't. Oh, let me clarify that.
Yeah.
You did not tell me all that stuff that I read. I want to be fair. You did not tell me all that stuff.
Yeah, I think everybody could agree with that.
Basically, I require the court to show I, a man in law, where there is a requirement for a man to have a license to take and carry my property where I may wish. And whoever acts on my behalf is under full liability. That's it.
Yeah, well, that's what I'm saying. It was different questions. Those are different questions. You can't just make it one long sentence. That's ridiculous. It sounds no. And you put everything in writing before you walk into the court. You don't open your mouth. You know, the judge said, you got anything to say? I don't want to go back to jail, sir. You threw me on the ground, beat me up last time. I don't want to go back to jail, sir. I said, it's all in the writing, sir. I got it all before the court, sir. I answered the court, sir. I wish to remain silent, sir.
And what will they normally do?
The answer's before the court. So they'll have to react to your answer. They'll say, well, you know what, we don't give a crap. And they'll roll it up in a ball and bounce it off your head and say, take them away. Or they'll say, okay, fine, case discharged. I don't know. Depends how the judge feels that day. You're at their mercy. That's it, buddy. You know, you never should. You should have how to carry yourself. Dude, the minute that you got arrested was what day did you get arrested? What day did this all happen?
I believe it's like November 18th.
So on November 19th, you had your answer to the prosecutor. You already had everything written out. You were already talking and negotiating with the other side of the settlement.
No, I was in prison. They brought me right to jail.
Okay, so the minute they let you out, you went right over?
No.
And for some reason you decided to wait till the day before trial to call me?
Yeah.
Yeah, so what do you say about that, Gus? This is your show, Gus.
All right, I have a simple question for him. We're going to see what happens.
Gus, explain it to people. It's your turn, Gus. Explain it to people what happens when you wait.
If one would have had the ability to talk to the prosecutor either the next day or, like you say, as soon as you get out of the Crowbar Motel, what would you say to the prosecutor?
How would you talk to him? Vocally or in writing?
Verbal. Well, probably. I don't know. If it was verb, I'd like to do it in writing and make sure he got a copy of a certified mail or a proof of mailing that he received my notice. But what would be in that notice? Either or, verbally or written. What would be in the written notice, and how would you talk to him? Carl said talk to him. What did Carl mean? In writing or in verbally? I don't know.
All right. Here's a letter I just wrote recently to a prosecutor. Exactly what you're talking about. It says, I, a man, write to you, the woman I believe sometimes acts in the capacity of a prosecutor for such and such a county, to inform you that the August 3rd activities of Officer so-and-so, the man that sometimes acts as an agent for the such and such police department, did and does continue to be the causal source of harm, injury, and loss to I. Likewise, your pursuit of case number so-and-so does cause harm, injury, and loss to I. I do realize you might not be aware of said causal source of trespass against I, and hope you will now reconsider your pursuit of said case. I hope to soon receive written notice of your intent. Kind regards.
Okay, that's starting to create a dialogue without going to court.
Yeah, you just, hey, I don't know if you're aware of this, but, government exists to secure rights and protect property. And I don't believe that there's a man on the other side seeking any kind of compensation from me. But if there is, I'm willing to settle out. But meanwhile, this pursuit of yours is causing me harm. And you might not have realized that you were causing me harm, but it is. And now that you do know, and there is no more, you wouldn't say all this stuff, but basically what you're doing is you're eliminating plausible deniability. Okay, they can't come back later and say, I didn't know I was causing them harm, because you sent them a letter. So you do everything in writing. And do you send it, registered mail, certified receipt return, and all that stuff? No, you just send them a letter. You send them a letter, and if they don't answer you 5 days later, you say, Dear Bob, I wrote to you a week ago, 5 days ago, and have yet to receive a response. This is kind of important to me. I hope to hear from you soon. I've included a copy of the first letter for your convenience. Kind regards. And when he doesn't answer you, you write to Bob, and then to Bob's boss, the town manager, and say, Dear Bob, this is the third time I write to you. I've included a copy of my first 2 letters for your convenience. I hope to hear from you soon. Dear Frank, I've written to Bob 3 times now. I haven't heard anything yet. Is Bob still alive? Is there somebody else I should be talking to? You just start writing letters. And if Bob doesn't answer, Frank don't answer, you write to Susie. You just involve more and more and more people. So do you need to have certified letters? No, you're writing a letter to some third or fourth party, and you're including all these letters. One of them is going to call Bob and say, Bob, I just got, this guy just got a hold of me saying he wrote to you 6 times and you haven't answered yet. And, the letter he's writing to me about said, are you the man responsible for dealing with this situation? Do you have authority to deal with this? It was a pretty simple question. How come you didn't write to this guy?
Okay, it sounds like you did a lot of writing and people aren't responding. And but normally you only have like 10 days before you have your time in court. So the first letter, you might get that out.
You don't have to. Whoa. What do you mean 10 days before you have your time in court?
But so you get a traffic ticket, and you have 10 days to respond.
But you said you'd have it in November, so that's a big, long 10 days. He's on California. He's on California
10 days, I was in the court. I was in the court the first time.
What was the charge in November?
It was false identity. When he asked me my name, I told him my true Christian name, but he didn't like that. He wanted the all capitalized corporate name, and he says, "Well, that's given a false identity, and you could have just been on your way with a traffic ticket, but I'm going to throw you in jail."
Yeah, so it's got nothing to do with a traffic issue. It's got to do with a misdemeanor.
False identity and full house for all traffic charges. Full house. No driver license, no inspection, no registration, open exhaust, everything.
Why didn't you just tell them that you go by the name of Tater Tot?
No.
You see what I'm saying? Why don't you go with the simple thing? Say, they call me Tater. They call me Tater Tot. Tater for short.
Yeah, I like the asshole one myself. Some people call me asshole, right? You call me asshole.
I'll agree with that.
I second the motion.
It carries. It's carried.
Third motion.
But anyway, but that's the 10 days. The 2 letters, you don't get a chance. They're not going to respond to the first one in 5 days, and by the 10th day, they're not even going to get the second letter. And then you're it. You okay? Well, 10 days to respond, and you got some more time before they schedule you.
Why were you in there for 10 days? Was that to enter a plea? Did they want you to come in for a probable cause?
They want you to enter a plea within 10 days. So I never entered a plea. I never signed anything or entered any plea.
So you put a notice into the court. It says, I, a man, appear solely as a man to settle any debt that I may owe, or to answer any, my accuser, the plaintiff, whatever. And if anyone acts in my behalf, then they assume all liability. I'm here to settle any account. And if anybody acts on my behalf, they assume liability. Just a simple notice. I'm here. Where's the plaintiff? Where's the accuser? Who says I've done harm? Who says I breached a contract? Why am I here? I got this wonderful invitation. I'm here. Your turn.
And if they don't respond?
I'm going home.
And no response is a response.
Yeah, a non-response is a response. You give them an opportunity to answer.
And when you bring it before the court's supposed to take notice that their response was dishonorable.
And then if you never made a plea, you couldn't make a plea because you demanded to know the jurisdiction from the actor to prove that he has jurisdiction or not, and you give him so many days and he fails to respond.
And you put it all in writing?
Yeah.
Can we see it?
Yeah.
Well, he hesitated.
Yeah, I have it notarized. And presented it to the actor, and he handed it back to me. And he says, you know what he says? He says, I'm a corporation.
Well, did you write it to the corporation, or did you give it to the man, Bob?
I gave it to the man.
Okay, was it addressed to the man? Did it say Bob?
I handed it to him directly in
I'm
court.
Required to know. Yeah, but who on the piece of paper were you saying that you require this information from the prosecutor for this particular county?
No, from the accuser. The law says that the Supreme Court at least says that when you're accused of when jurisdiction is challenged, the accuser must respond to that with the proof of the jurisdiction. If not,
you're talking about a contract violation.
I'm talking about with a Supreme Court case law about jurisdiction, subject matter jurisdiction.
I understand. But your issue had to do with a contract. They're considering you a person under contract with the state to perform very specifically, and you did not perform, so they're assuming that you have violated the contract.
Yeah, and then
you're not a man with rights.
Yeah. Oh no. But I'm not under their contract because I don't have any of their licenses. Okay. I don't have any of their licenses.
It's called a rebuttal. Try that, Gus. It's a rebuttal, and I'm about to take off. So yeah, work with rebuttal, and that's the way you should be going with this man. That he never rebutted that he was not a person, that he was a man, and that they got him in the wrong jurisdiction. They got him, they got the wrong person. Okay, work with that. But like I said, I'm taking off, so I'll talk to you soon, okay?
Yeah, have a good flight.
All right, take care, guys.
Bye.
Okay, bye.
Wow. That's up to the minute. That's literally Karl on the fly.
What did he say about the rebuttal? The rebuttal is by the actor who you demand the response from.
The court that you're in is presuming all sorts of things, and you did not rebut the presumption.
Oh, rebut the presumption.
You rebut the presumptions by putting in a notice into the court. I am a man. I appear only as a man, and I appear only to settle the account privately, or I appear only to, actually, let me read you the one I wrote on that this week. Let's see. I, a man, appear before this court solely as a man, without representation, without title, defendant, pro se, driver, operator, to give notice as follows. I am an idiot in legalese. I do not understand the customs of the legal society, nor do I believe any law exists which requires man to know or understand these things. I believe the government exists to secure rights and to protect the property of man. See Exhibit A. My Exhibit A was everything to do with an idiot, everything to do with legalese, everything to do with the customs of the legal society, and I included the Declaration of Independence, the part that says that they're there to secure rights, and Article 12 of the New Hampshire Constitution, which says the same thing. So, that's a total rebuttal of all the presumptions they have.
That sounds beautiful. Beautiful combination of words.